the former Nigerian Bar Association president, Dr. Olisa Agbakoba, SAN, has alerted the National Assembly about constitutional issues concerning law enforcement agencies, particularly the Economic and Financial Crimes Commission, which he claims are unconstitutionally established. In a letter dated back to October 14th of this year, addressed to the Deputy Senate President Barau Jibrin and Deputy Speaker Benjamin Kalu, Agbakoba has argued that the EFCC exceeds the National Assembly's powers and hinders the government's anti-corruption efforts outlined in Section 13 of the 1999 Constitution. He expressed support for the ongoing legal challenge by 16 states contesting the EFCC's legitimacy, stating this move could clarify the commission's validity. Agbakoba called for a public hearing to discuss necessary reforms within Nigeria's legal and institutional frameworks, emphasizing the need for coordination amongst law enforcement agencies in combating corruption. The Supreme Court is set to hear the case on the 22nd of October. And joining us now, we have a conversation around the legality of the EFCC establishment and the call by former NBA President Dr. Olisa Agbakoba on the National Assembly to review this Constitution. We have Adeyinka Olumide-Fusika, a senior advocate of Nigeria, here to discuss this with us here on Newsday. Thank you for joining us.
Thank you for having me here.
Well, I'd say that many would agree with what Dr. Agbakoba has pointed out in his letter, that the powers under which the EFCC were established go beyond the powers of the National Assembly and therefore make it unlawful. What is your take on this discussion?
Well, first of all, I must start by acknowledging the role that Dr. Olisa Agbakoba has played in bettering the current democracy. Without a sacrifice of blood, under the military, maybe we will not be where we are today. So I understand this, that he's disappointed about the situation of the country, especially when it comes to law enforcement, the adjudication of disputes in society, and so on and so forth. But I do believe that I would say that maybe that has affected his disappointment, has affected his I don't want to be his perception of these issues, which I think he should I would urge him to look at again. Of course, I disagree with him if he says from what I read in the papers, that he said the EFCC is an unconstitutional body or something like that. I completely disagree with him. And when he suggests that the body was set up outside the legislative competence or powers of the National Assembly, I also say that that is not. I disagree with him respectfully on that. We need to be careful because this is an issue that is already before the Supreme Court. So I think that is a many-pronged attack on the existence of the EFCC, court, legislature, and all that, so that if one does not work, maybe the other one would work. So I disagree with him. It's not. I would strongly suggest and argue that the legislature, the National Assembly, in making that law, the EFCC Act, did so within its legislative competence. If one has to, I said we have to be careful about the case in court before the Supreme Court. We are not supposed to be making comments and all that. We should allow the Supreme Court, the masters of the law, in Nigeria to make a decision on it. But I'm tempted to just quickly make a comment that if I were to be arguing before the Supreme Court, I would strongly argue and contend that the entire basis of the suit before the Supreme Court is very, very doubtful. The entire basis is that the EFCC Act was made pursuant to the UN Convention, and that under the 1999 Constitution, Section 12, the National Assembly didn't have the sole right to pass that law without the concurrence of 2/3 of the states. And I would say that that is putting historical facts upside down. The EFCC Act was first made in the year 2002. And you can check this out. The UN Convention that they are talking about came into effect in October of 2003. So it is wrong. I mean, it is not correct to say that the making of the EFCC Act was based on the convention, the UN Convention that was made in 2003. That alone should put an end to the entire argument that the National Assembly made the law without consulting the State's House of Assembly because the law is based on the UN Convention. The act was already in existence. And I think the case that they are citing, the case of Dr. Nwobike against the Federal Republic of Nigeria, I think they are just misinterpreting, misapplying. I would strongly argue, if I were to be, I'm handling the case, I would strongly argue before the Supreme Court that, that contention is also not, it's just, they are saying in that decision what they want to see. Because all that the judge said, or the justice of the court said in that case was that there is an Article 15 of the UN Convention, which is against bribery and corruption. Are they suggesting that before the 2003 UN Convention, bribery and corruption and so on were not illegal in Nigeria? Were they authorized? We have all the criminal codes that's all over the place. These have always been crimes in Nigeria. We don't need the UN Convention to tell us that collecting bribe and so on and so forth are criminal offenses in Nigeria. But like I've said, the EFCC Act, go and check it. You can verify it was 2002. It wasn't 2003. The convention they are talking about came into being in 2003. So how can you say that they made the act and so on and so forth based on a 2003 convention that was not in existence when it was made? So that's the suggestion. I will also strongly contend before the court that if you look at the Section 12 of the Constitution of Nigeria that they are talking about, if you look at Section 12.2, which is what they are basing it on, it only says that you need the concurrence if a treaty deals with a subject outside the exclusive legislative list, which belongs solely to the federal government. If a treaty deals with it, then you need the concurrence of 2/3 of the states in order to domesticate such a treaty. Where it is within the exclusive legislative list, then you don't need the concurrence of the states on that. And if you look, you go to the 1999 Constitution, there are about, I think, if I'm not mistaken, about 60 items on that list. 60 items on the exclusive legislative list. And if you look at, just give me, you go to, for instance, item 31. Item 31 of the exclusive legislative list says, deals with implementation. The federal government, the National Assembly has the right to make laws on implementation of treaties relating to matters on the exclusive legislative list. That's item 31. You go to item 45, deals with the right of the National Assembly to make laws on police and other security services established by law. The EFCC is a security service, so how can you say that if you go to item 60, it talks about the establishment and regulation of authorities for the federation or any part thereof, to promote and enforce the observance of the fundamental objectives and directive principles contained in the Constitution.
Now, if you
and then you go to item 68, it says, any matter.
Well, if you allow me to interrupt you, please. Apart from saying, yes, I can hear you.
Yes.
Apart from saying, that the EFCC is unconstitutional, He also noted a lack of cooperation between the law enforcement agencies. And I'm sure you're aware that some civil society organizations have also been raising concern about selective, prosecution of elite personalities by the EFCC. When we do have some serving lawmakers and party leaders who also have cases that have not been prosecuted. So I'm wondering, if you say the EFCC is constitutional, then should it be reformed?
No, so you see, there are two different. You now get the point I'm trying to make between when you say the body itself is unconstitutional. You want to throw away the baby with the bath waters, as they say. You're saying that you are disappointed. In my introductory comment, I said he's obviously disappointed with what has been going on. There's no doubt about that. If you go, I am in contention with the EFCC in so many cases. I defend people against them when I believe that they are going outside their remit. I fight them, I write petitions, and so on and so forth. But that is quite different from saying the body itself is unconstitutional. When you say it is unconstitutional, it means all the trials they've had since the body was set up, the convictions, the forfeitures, and all that, everything becomes null and void. There's a difference between the two. You cannot say, if you say, for instance, that, I have cases where I've taken them up on some of their officers involved in corrupt practices and so on and so forth. Like I say, it's a Nigerian institution. You have Nigerians working in that institution. So you cannot, it shouldn't be strange to us that some, within the organization may be selling investigation, selling prosecution, but that doesn't define the institution as a whole. You just have bad eggs that needs to be dealt with or to be corrected so that they change their ways. To now say that the body is unconstitutional because you are disappointed, you've had nasty experiences, and I grant him that what he said about non-coordination and all that. I will tell you straightforwardly, since 2002, if you look at the level of corruption in 2002 to what it is now, it's even worse. So you can question how effective has this organization. Can you hear me, please?
Yes, we have exhausted our time, but we do get your point. We do get your point. We hope to have you back another time. Thank you so much for joining us for this conversation today.